of the state of Maryland. He's had a couple of brief periods where he lived in other states. And in fact, I understand that right now, just recently, he's relocated to North Carolina. He's never lived in Texas, never really deliberately did business with, he's never really conducted any kind of business in Texas, never lived here. He's been sued in this matter where he was acting solely in a representative capacity for his employer, and who he no longer works for. There were two contracts signed, which are attached to Mr. Friedman's, both to his second amended petition and to his response in this special appearance matter. There were two contracts signed. Mr. Nike signed as a vice president of North Star Hotel Groups. He was not the owner of North Star Hotel Groups, not the principal in that company, but he signed those contracts as a vice president. If we call him to testify, he will say that his initial contacts were with NTRG, were with someone in Florida. Admittedly, NTRG, its principal place of business is in Dallas. But Mr. Nike did not know any of that. It's a little unclear about who contacted who initially. NTRG stands for National Tax Resource Group. They provide services to help companies with their property tax bills. And I think it ranges from appealing appraisals and other services related to property taxes. I may be oversimplifying what they do, and Mr. Friedman can elaborate on that. But the whole dispute here is whether Texas is the appropriate place for Mr. Nike to be sued. And this thing has kind of morphed from, it was a simple breach of contract suit initially between NTRG and North Star Hotel Groups. But there were some difficulties in obtaining service, which Mr. Friedman, I'm sure, will go into. And Mr. Nike was brought in as a personal defendant, and I was employed to represent Mr. Nike. And we're simply contending that whatever he did as a resident. First of all, he didn't do it in his personal capacity ever. He was operating on behalf of his employer, and he wasn't even aware that he was dealing, at least not initially, that he was dealing with somebody that had operations in Texas. And so we just don't think the case belongs here. If they think they have a lawsuit against Mr. Nike, they need to bring it in Maryland or wherever he lives now. But he did not have minimum contacts with Texas.
Response?
Your Honor, I submitted my response in opposition to Mr. Naik's special appearance last week. As evidence therein, NTRG contends the facts evidence that Naik conducted business in Texas, and that his contacts with Texas were directly related to the claims in this case. Now, the central contention of this lawsuit is that Naik defrauded NTRG by representing to be the vice president of a company that didn't exist at the time and may have never existed, and by representing that the company would pay the agreed fees per the service agreements that have been presented to the court in order to receive professional services from a Texas-based company. Based on that alone, by defrauding NTRG, a Texas company whom he contacted with to perform services on his behalf, Naik availed himself personally to the jurisdiction of Texas. NTRG's principal place of business is in Dallas, Texas. The Civil Practice and Remedies Code does state that when a non-resident recruits Texas residents for employment, this can constitute doing business in Texas. Although not all work, admittedly, is performed in Dallas, Texas, all clients work through and or with the Texas office. This is an undisputed fact sworn to by Debbie Garcia, a partner at NTRG. There's not a client that NTRG has that does not have an administrator assigned to them, and all administrators are located in Dallas, Texas. As you'll see in Exhibit 3 attached to Ms. Garcia's affidavit, there are voluminous emails between the parties, which includes the administrator at the Dallas office. Further, Mr. Naik entered into 2 contracts with NTRG. Both have been presented to the court, one in 2013 and one in 2016. Both contracts on top show National Tax Resource Group, Dallas, Texas. He's fully aware that it was a Texas-based company. Further, in the contracts, there is language, which I'm scrambling to find the exact language on my mouse, but there is language to the degree letting him know that any actions arising out of this agreement shall be governed by the laws of the state of Texas. Venue for any action between the parties arising out of or in connection with this agreement shall be in Dallas, Texas. Based upon the amended petition, and there was a disservice issue with North Star Hotels Group, the other defendant in this case. We served them at their alleged. We served them at their alleged principal place of business. Never got a response. They're not registered to do business in the state of New Jersey with the Secretary of State in New Jersey, New York, Maryland, or Delaware, or Pennsylvania. So upon information and belief, we don't think they exist. We think Naik, and we contend in our petition and in our response that Naik entered into these contracts based on behalf of a company that does not exist. He, as potential owner of the properties, received tax benefit rewards for NTRG's work that they did on behalf of those properties, and he availed himself to the jurisdiction of Texas.
Mr. Ponder, what case law do you have to support your position that minimum contacts don't exist here, and how do you circumvent the choice of venue clause in this case?
Your Honor, I can't point to any specific case law to any cases that are similar factually to this. All I can say is I think the introduction, Mr. Friedman's introduction of a fraud allegation is really kind of a red herring when it comes to whether Mr. Naik had minimum contacts with Texas, because whatever he did, he did in a representative, first of all, in a representative capacity for the people he worked for. He wasn't privy. His testimony would, if called today, his testimony would indicate he was not privy to the organizational documents of the company. He was not an owner in the company. And he went to work for these folks and worked for them for a number of years and isn't associated with them now. The plaintiff had every opportunity to do its own due diligence about who it was doing business with, and they never did that. If there was a problem with corporate existence, this group of hotels did consist of about 4 different hotels at different times, and so they didn't do their own due diligence about who they were doing business with, and they ran up a debt. It was something that Mr. Naik did on behalf of the people he worked for. He was just being paid a set amount per month to work for them. It was not part of ownership. And it's just fundamentally unfair to drag him down to Texas now to defend a case for people he hasn't worked for in years. And so So that's why we're here. And it's they factually, I think they just don't have a case for saying that he did business in Texas.
All right, I'm going to go ahead and deny this special appearance. Mr. Friedman, if you could go ahead and prepare an order on that, email it to Rhonda as well as e-file it. Make sure it says on the first page that this hearing was heard on, and again, I don't have the calendar. I think today is October 1st. On October 1st, or whatever today is, that this hearing was held, and make sure you get that filed if you can today. Also share it with Mr. Ponder. Anything else, guys?
Absolutely.
That's it, Your Honor. Oh, one thing, Your Honor, I want to call to your attention. This case is on the dismissal docket again Monday, and I'm not going to be able to attend that hearing. I'm not going to urge dismissal of the case under the circumstances, at least not at this time. I just wanted to explain to the court why I won't be present on Monday, because I'll be traveling. And maybe we could just go ahead and dispose of that today.
Yeah, that's fine. What is there? No one's filed an answer. So yeah, let's go ahead and just set this for trial. When do you want to set this for trial?
We're going to need a while. And let me tell you why. There's going to be a substitution of counsel. I'm not primarily a civil trial attorney, and I jumped into this to be helpful. Mr. Zolden and I need some time to get, hopefully get him on board. He's going to apply to appear in this case pro hoc vice. And he's familiar with the facts, but if we have to get another Texas civil trial attorney, they would have to get up to speed on the case. And obviously we need time to file an answer. But I think it's going to be a little while before the case can be developed factually. And Mr. Zolden has done some limited discovery on the jurisdictional issue, but there has not been general discovery done on either side.
Okay, what sounds good then?
Your Honor, I'd suggest late spring, early summer of 2022. And obviously, if Mr. Naik retains new counsel and it's a problem with him, I'll conference with him. If that's acceptable to you.
It's fine with me, Mr. Ponder.
Yeah, that's fine. I think that gives both sides adequate opportunity to prepare.
All right, why don't we, how does June 7th sound?
Works for me, Judge. I don't have anything scheduled that far out. So
works for me as well, Your Honor.
Ronnie, go ahead and set this case for trial on June 7th to take it off the DWAP docket. Okay, Rhonda. Okay, we got it. Earl, go ahead. And
thank you, Your Honor.
that. You guys be safe, okay?
Thank you for your time.
We will.
You as well. Take care, Weldon.
All right, thank you.
Okay, let's deal next. This should be pretty brief with the David Jackson case. Or is counsel here for that? David Jackson versus the Preston Condominium Association's case.
Yes, Your Honor. Helen Emerson for the defendant.
And Christine Alstrin here for the plaintiff, Your Honor.
Okay. I had a request, I don't remember from which side, to do this hearing live, and we're not really doing many hearings live. So I just wanted to get a feel for why we would need to do this one live as opposed to via Zoom, where we're not putting anyone in jail, right?
No, not today, Your Honor.
Okay.
So plaintiff's counsel requested, plaintiff's counsel filed a motion to appoint a receiver to take over management of the defendant and the building at issue. Plaintiff's counsel requested that be an evidentiary hearing on that motion, October 11th. We do not agree that it needs to be an evidentiary hearing. We think this is something that can be decided by affidavits, briefing, and argument of counsel on Zoom. A few reasons for that. I know Your Honor's trying to keep it brief. You got a lot going on this morning, but I'm happy to explain my reasoning on why this does not need to be an evidentiary hearing. But if it is going to be an evidentiary hearing, given the nature of the relief requested by plaintiff, it's very important for the defendants to have this hearing in person so that we can ensure all witnesses are there, prepared, focused, and can be properly confronted on cross-examination. Because if this were to happen, it would have very serious and potentially devastating consequences for hundreds of owners in this building. And to go back to why we don't think that this needs to be an evidentiary hearing, the motion is incredibly ill-timed. It was filed 8 days after a new management company took over operations at the building and 4 months after a new board was elected. So the complaints that are described in the petition, in the motion, to the extent that they're actually supported by any evidence, they're based on old issues governed by people that are no longer managing the building.
So are you the one who requested the in-person then?
If it's going to be evidentiary, yes, that's why we put our request in for it to be an in-person hearing.
Ms. Alstrom?
Well, obviously, I disagree with the characterization of our petition and our relief, our motion and our relief. I think it does need to be evidentiary hearing. I think we're allowed under the rules to do so. I don't see why it needs to be in person, completely via Zoom, and presented witnesses subject to cross-examination. We've had no issues with that whatsoever. I don't see that there's been a compelling reason offered by Ms. Emerson as to why we would sort of deviate from that at this point in time. Just on a personal note, I know Mr. Payne both has grandchildren that are under the age of 12 and cannot be vaccinated. I have 2 children in my house that cannot be vaccinated as well. And I have an 81-year-old father that cannot be vaccinated. Supposed to be there in person. I would certainly respect that from the court, but I just don't see that is the case. And I believe the court has the mechanisms and has done so in order to conduct a hearing that's fair for everyone and allows them to examine witnesses and cross them as needed.
I agree with you, Ms. Alster. I don't think we need to do this in person either, unless we get to, what my general view is that as long as we're at red in Dallas County, I'm going to do my hearings, if at all possible, remotely. If it gets the orange, then I'll be much more flexible in terms of allowing hearings to be conducted in person, but I don't anticipate that will happen by next Friday. So let's talk about the issue of, does this need to be evidentiary? How many witnesses are we talking about for an evidentiary hearing?
Your Honor, I believe at most we would have 3, and I anticipate maybe some of that would even be presented via deposition. I'm in the process on it. I don't want to burden the court. The testimony will be very short. Obviously, I can't control the extent of cross-examination, but in terms of our witness, our questioning will be very short on our side.
Ms. Emerson?
I'm not sure who the third witness plaintiff's counsel is referring to. I assume maybe, are you talking about plaintiff? Because we received 2 notices of intent to serve a subpoena on 2 witnesses. In addition to those 2, is your third plaintiff?
Potentially, I've not made that decision yet.
Okay, because we would need to call the plaintiff, and then we'd have at least 2 other witnesses. We've also been approached by 2 other owners in the building that are concerned about this motion. So we may, to demonstrate the damage that that the relief requested could cause to those owners, we may have 1 or so of them to appear as a representative. So we have at least 3, potentially 4 witnesses in addition to the 2
So
that plaintiff
she's
has.
requesting depositions from 2 people. She's done a subpoena, Ms. Emerson, is that right?
I believe it was a subpoena to appear at the hearing to testify.
Oh, okay.
Yes, there's a subpoena, and let me clarify, there's a subpoena to appear at the hearing, but I expect notices to go out today for 2 witnesses. And what I will do is, if the hope is to be able to present that video deposition testimony at the time of the hearing, if I can secure those timely. And that way that should speed up the process, Your Honor. That's the hope, because I don't want to bog down the court. And I would just apply it.
We haven't discussed setting depositions in advance of this hearing at all, so I don't know
Well,
anything about
I do
those.
think, Miss Emerson, that that's a good idea to do this via deposition as much as you can. So is there,
We may need to
is the hearing
postpone
set next
the
Friday?
hearing.
I'm sorry?
Sorry, we may need to postpone the hearing if we need time for depositions in advance of it, because I've got a trial setting out in Collin County and we're about a month out. So,
well, the alternative, because I really don't want to postpone the hearing and use the alternative, I could just call them live, and I'm fine with doing that. My thought was just if I did it via, if I noticed the depositions in advance of it, it would allow the hearing to proceed more quickly. That way we could just play the relevant clip. So I'm doing that in an effort to move this along. If Ms. Emerson's not present for deposition, I'm sure someone in her office could be there for purposes of examining the witness. And if not, and that's just not something anyone from their office can do, I think I'm entitled to notice those depositions of those individuals, and they can attend them if they choose. Alternatively, I could call them live at the hearing, but that really seems to sort of be more burdensome for the court.
fine with doing the testimony via deposition in advance of the hearing rather than calling them live, but it's just the timing of that is.
Miss Emerson, you
Problematic.
said you had a trial when at the beginning of November?
Yep. Yes, Your Honor. Sorry.
Could you do depositions over the next couple of weeks?
Over the next couple weeks, and I can certainly try. Council hasn't conferred with us on dates for any of these depositions yet, so I really don't know what I'm talking about yet.
Why
I like that.
Why don't we put you guys into a breakout room so you guys can talk about this, figure out, I mean, whatever we can do to try to shorten this. And you don't even have to play video clips. Just give me the depositions with line and page designations and I can read them. I don't think it's that hard. And we can submit that to the court reporter. I mean, we can do this a lot quicker, submit a couple applications.
Right.
Maybe
But that was
have-
right. And that's what our position is from the beginning. We can do this on affidavits on paper without live testimony, but
if they want to do depositions, they can do that too.
certainly.
So why don't I put you guys, is it just the two of you here for this case?
Yes, Your Honor.
I also have, I'm sorry. We also have a new associate in our office, EJ, who I think is on this as well, but I'm on my phone, so I can't confirm it because I can't see y'all, but I believe that he is on there as well. So if Your Honor could transfer him into the breakout room as well, I would appreciate it.
EJ Odre.
Yes, Your Honor.
Yes.
All right, I will put you guys into a breakout room. Okay. You guys try to work everything out. Whatever you can't work out, just come back in and but try to get this done as quick as you can, okay?
Thank you, Your Honor.
And yes, Your Honor, I'm sorry, just from a technical, how do we alert you that we would want to come back in? Or maybe Helen knows how to do that.
Yeah, you can just come back in. You can
Okay.
just leave the breakout room.
Perfect. Okay, I appreciate it. Thank you, Your Honor.
No problem. Good luck. I think the next case is the TRO that was filed. Is that correct?
Yes, Your Honor. I think so. I think that's all I see on the screen.
Okay, who's here for that?
Okay, Your Honor, Tricia Macaluso on behalf of the plaintiff, Mr. Shen. Along with me on video is my associate, Jacqueline Gallion. We're both with Brian Cave, Leighton Paisner. Last time I was in front of you, I was with Norton Rose, so I've switched firms.
Yeah, I remember that.
Yeah. I was like, you had a look on your face. I'm like, I've
No,
switched firms.
everybody's switching firms these days.
There's a lot of movement. Yeah, there
A lot of
is.
movement. But
Yep.
great firms, Brian Cave and Norton Rose.
Thank you.
Okay, so we're here.
And I'm sorry, Your Honor, I didn't mean to interrupt you, but we were able to get in contact with the defendant and they have retained counsel and he is on, I see, it looks like Mr. Spencer is on the Zoom.
Morning, Judge.
Good morning.
Arnold Spencer, appearing on behalf of Pan American Taekwondo Union, a Texas corporation. I am joined by my associate and counsel, Amy Castlegray.
Okay, so this got filed yesterday, and I got a chance to briefly look at it. So let's kind of give me the lay of the land.
Okay, Your Honor.
I'm
happy
sorry,
to do.
Your Honor, just a housekeeping matter, if I might. I don't mean to interrupt the plaintiff. I know they have the burden; they get to go first. But as just a preliminary matter, I think it needs to be addressed, sort of standing jurisdiction here of the court. I want to make it clear that we represent the defendant that's been named and served in this case, which is Pan American Taekwondo Union, a Texas corporation. That company, that entity was formed about 3 months ago. And it was formed by 3 individuals who are associated with Taekwondo internationally. That company is separate and independent from a number of other companies with which Mr. Shin, the plaintiff, is affiliated. Is it possible for me just to briefly screen share an overview document that I prepared?
I'm unclear. What is the jurisdictional issue?
I don't think they have sued the right party. And I don't think they have standing to bring a case in Texas.
Okay.
Well, we're going to address, we do address standing in our motion, Your Honor, and I'm happy to address that through the course of my presentation.
No, Your Honor, what they do is they identify, and they really don't they don't identify the legal entity. They just refer to it as Pan American Taekwondo, and that's not a legal entity.
It is the one registered with the Secretary of State. I did pull the Secretary of State's registration, and with the Secretary of State, it says Pan American Taekwondo. I found it odd that it didn't match the name that you're talking about, Mr. Spencer, because that's the entity with whom we dealt with, but it is the one that is set up by Mr. Rafferty, who is the person who is in charge.
What they do, Your Honor, is identify my client, and then they attach documents and make allegations about other unrelated entities with whom Mr. Shin does have a relationship. These New Jersey entities and these Oregon entities. Again, if I could just screen share and give you a name.
Your Honor, if I may present my presentation and go through the motion that's before the court, that would be much appreciated. And then during his opportunity, Mr. Spencer can address all of those arguments during his response. That there's nothing improper about what we've done. I've filed and I've served an entity. If he doesn't believe he's the right entity, that's one of the defenses he can bring up in his presentation. But he's hijacking this.
No, I'm happy to sit here and listen. I just don't think it's efficient use of the court's time. If the court wants to handle it that way, I'm happy to.
Well, let's do this. Let's first off deal with the issue of standing. So let's just hear argument on that. But I'll let plaintiff's counsel go first on that, and then we'll hear from Mr. Spencer.
Okay, Your Honor. So we have sued an entity named Pan American Taekwondo. Hold on 2 seconds. I was going to pull up. I'm pulling up the Secretary of State's sheet that I have on that because the entity is called Pan American Taekwondo. It's registered with the Texas Secretary of State, and it Mr. Rafferty, Haas, HOSSRAFATY, is its registered agent and officer. It appears, at least in the filings that were filed with the Secretary of State. It's listed as a nonprofit corporation created to promote any lawful act or activity in the interest of World Taekwondo and Pan America. It's our understanding this is the entity. This is also the entity with whom we have been corresponding, and that also is reflected in the letters attached. They go by PATU, it's the an acronym, if you will, that they go by in the Taekwondo world. Is a way of background just so you can understand the how they fit in. You have World Taekwondo, and then you have PATU, which is the regional governing body for Taekwondo effectively in the Western Hemisphere. And this entity is the one that is currently running that. Depending on who is in charge under their bylaws, they set up a new entity in that person's home, if you will, or in their residence. Mr. Rafferty is currently involved in the interim governing committee that is involved in running Pad 2 while it is waiting on its presidential election. And thus, we have an entity that was formed this summer by Mr. Rafferty to run Pad 2. The reasons why we have jurisdiction in front of this court is we have sued for declaratory judgment, but we have also sued under the Texas Business Orgs Code dealing with invalid corporate acts. This is an invalid corporate act that we're addressing, dealing with Pad 2 not following its statutes and its bylaws. Mr. Shen is a member of that particular organization, and as a result, he has standing to bring this claim.
So the minutes say that it's WT Pan Am Reform.
That was, no, that's not. It's, if you will look at exhibit, 2 seconds.
I'm just looking at the exhibit you provided. I'm not.
Oh yeah, no. I want to direct you to the, no. I want to direct you to the correct one. So the minutes that deals with, that is something that it's a bit incestuous, quite frankly, Your Honor. World Taekwondo and Pad 2, they seem to be run oftentimes by the same people from what I can tell thus far. I'm new to this. But that being said, those minutes deal with the background facts. Those were provided to kind of give some flavor and background as to why we are here, which deals with the election for president of Pad 2. Okay. Mr. Shen wants to stand for election to be the president of Pad 2. Going back, Mr. Shen was involved. He's been involved with World Taekwondo and Pad 2. In 2018, he effectively whistleblew. He was serving as the Secretary General at that time. He was a whistleblower and advised World Taekwondo and those within Pad 2 that the current president at that time, Mr. Choi, was engaged in mismanagement, to put it nicely. And so he was the whistleblower that brought that up. So the minutes are the result of an investigation where they have made these determinations about what Mr. Choi was doing as a result of the whistleblowing. So for example, on the minutes, as exhibit on like page 2 of exhibit A1, that's in that paragraph where it says,
I'm trying to get a feel. Let me share screen real quick.
Yeah, show me where you are. That'll maybe help me because I'm trying to figure out where you were.
Okay, so.
Yeah. Oh, okay. You're looking at the notice. Got it. So that's the notice of charge. So that was the notice of charge that was given to Mr. Shen in July of 2021. Yes, that does have World Taekwondo at the top. We are not suing World Taekwondo. World Taekwondo has effectively charged Mr. Shen. They've painted him with the same brush as Mr. Choi while ignoring the fact that he was the person who was the whistleblower. So they are alleging numerous claims against Mr. Shen that are meritless.
What is your client trying to run for? He's trying to run for president of World Taekwondo or what, president of Pad 2?
President of Pad 2. And as a result of these charges being filed against him, Pad 2 has only conditionally accepted his application to be president. So they've said, yes, you can run for president, but it's conditioned on the outcome of these charges from World Taekwondo, and you cannot campaign, and you cannot contact the membership. So they've effectively said you can run, but you can't run because they're taking away his ability to run for president. While World Taekwondo, this dispute dealing with World Taekwondo is being dealt with via a tribunal, and we're pursuing his remedies in that particular venue because that's where we're supposed to deal with those issues. Those ultimate findings on the World Taekwondo claims are not before the court. What we have before the court is his request to be able to run in a fair election, which he doesn't get because of the way they've done this. If the court will look at Exhibit 5. So this is the conditional acceptance of application for candidate. And this is from Patu. So the Patu interim, I'm sorry, I'll let you get there. I think I had them bookmarked in the version that I emailed to the court, but I'm not sure if the uploaded one was bookmarked.
Okay.
Sorry.
Okay.
Keep going. You're almost there. There we go. Okay. So on this conditional acceptance, so this is from Patu. This is the interim management committee I was talking about. The Patu interim management committee, they reviewed his application to serve, to run for president. Then they say, based on your current situation, because they're aware of the World Taekwondo proceeding that's going on, and the fact that your appeal is still in process, which it is, and we don't have a resolution on that yet. They conditionally accept the application under the following terms. So we can't submit it, but approval is subject to the outcome of the appeal. We can't.
Let me do this. You're getting to the merits here. So
yes, I am. I'm sorry. I was trying to explain
let
that
me
to you.
ask Mr. Spencer. It seems like he's trying to run for president of Patu, at least from what I can tell. Why is this not the right entity? Mr. Spencer? Is he there? I can't, let me see.
I can't see.
Mr. Spencer, are you there?
I still see you, Your Honor.
He's still on. I don't see him.
I can't see any of the participants. It looks like Miss Gray is on.
Your Honor, I'm here. We're in different locations. It looks like he dropped off. Maybe he's having technical difficulties.
Are you his co-counsel or?
I am. I'm of counsel of the firm, so I hopped on to just be part of this. He's the one that has all the information. So my apologies, Your Honor. I couldn't continue or talk about his issues.
Can someone try to reach out to him and find out what's going on? Since we're
Yeah.
Because we have another hearing at 10.
Let me try to call as well, Your Honor.
Okay.
Your Honor, I got his voicemail. I'm going to continue to try. My apologies.
Right here, let me see. There's someone named Mr. Law is coming in. I don't know if that's him or not. That's very interesting name. Mr. Law. Hello, Mr. Law.
At least he's not a cat.
Sorry about that, Your Honor. My internet just bounced me. I've got my backup computer here.
Okay. All right. What part did you get cut out on?
I think she was going over the Patu, Oregon statutes.
So the question I have here is that, and again, just trying to figure out how these entities are related. It says here that the PATU Interim Management Committee is the one who has suspended Mr. Shar or
No, sir.
curtailed Mr. Shin from running. So
Well,
why is this the wrong entity? Is it
Okay.
the wrong PATU?
Let me briefly explain the bigger overview of entities. Start with the International Olympic Committee, the IOC. They oversee all Olympic sports and all Olympic sports entities.
Okay.
Among other things, they send money to the different member organizations of the IOC. For Taekwondo, they had previously been sending money to these Oregon and New Jersey entities that Mr. Shin was I'm sorry, I messed up. I skipped a step. IOC sends money to World Taekwondo. Now, you did see a letter from World Taekwondo in the plaintiff's presentation. World Taekwondo, in turn, historically sent money to the continental unions, the 5 different organizations around the world that supervise Taekwondo activities in each of their continental union jurisdictions. Those continental unions, as well as World Taekwondo, are independent corporate entities. And they have separate bylaws, they have separate bank accounts, they have separate directors. They are all independent. So IOC to World Taekwondo, World Taekwondo down to the continental unions. One of those continental unions has historically been referred to as PATU. But for the purpose of this legal case, it's very important to distinguish between legal entities, of course, because there are at least 4 different organizations, 3 of which we know Mr. Shin was an officer of, one of which we think Mr. Shin was a member of. But those are all historical organizations that at one time or another were recognized by World Taekwondo, but are no longer members of World Taekwondo. In June of this year, prior to June of this year, World Taekwondo stopped doing business with, stopped sending money to, and suspended the PATU Oregon, and prior to that, the PATU New Jersey entities. Those were the entities in which Mr. Shin served as an officer. World Taekwondo, not my client, but World Taekwondo then appointed the interim committee to form PATU Texas. And that is the corporate entity that was formed in June of 2021. Now, the critical factual dispute that I have with Ms. Macaluso, Mr. Shin is not a member of PATU Texas, and PATU Texas has not adopted and does not follow the bylaws and statutes and rules of ethics that the previous unrelated New Jersey and Oregon entities adopted. She's basically taking the position that all of these PATU entities are successor entities that all have taken on the bylaws and the corporate history and the liabilities. And that's just not true. That is just black and white incorrect. So these members, individual people appointed by.
So which company or which entity, I guess, is Mr. Shin running for? Is he running for PATU Texas or some previous PATU entity?
No, he would like to run for, and I agree with Ms. Macaluso on that, he would like to run for president of PATU Texas.
Okay.
One of the primary problems with that is he is not a member of PATU Texas. Now, he has submitted an application to run as president, and that application has been conditionally accepted, which is to say we are considering whether or not he meets the technically, legally.
So I want to make sure before we get into this. So I want to make sure I have the facts correct. So Mr. Shin has filed to run for president of PATU Texas. PATU Texas is the entity that was served and is your client, correct?
Yeah. Yes, sir.
Okay. I think that's enough. All I need to hear on the standing issue. Let's get to the merits.
Okay. So I'll backtrack, Your Honor. So we were looking at the letter, the conditional acceptance letter. That was Exhibit 5. So Patu, I'm going to call him Patu, Texas.
When is this election going to be?
It's next Saturday, October 9th.
October 9th. Okay.
Yeah, originally, I believe it was October 11th. The election was announced about the same time that Mr. Shin was served with his World Taekwondo notice of charge. Was back then.
Is this an in-person election or is this an election over Zoom?
That I'm not confident. I know the answer to
Spencer,
that.
do you know?
Perhaps, Mr. Spencer, do you know? I don't know.
I don't know off the top of my head.
I'm hoping they have COVID protocols and this is a Zoom one, but I don't know that, Your Honor, because it's a big organization across a large portion of the continent. So one would presume it's not in person, but that's a presumption on my part. It is October 9th. And obviously he made his application. We got this notification of conditional acceptance in August. And we have been pursuing the appeal process with World Taekwondo, which is a separate and distinct issue. So what I'd like to do is back up just a little bit, because when I was presenting things to you a minute ago, it was try to deal with why you had standing to hear everything. And now I'd like to kind of give it a little bit more order, if you don't mind. So obviously to be able to have a temporary restraining order issued, I need to show that I have a cause of action. I have a probable right of relief or recovery, and that my client is about to serve, to have imminent and irreparable harm or doesn't have an adequate remedy at law. Here, since the election is October 9th, if he is not allowed to stand for the election, or the election is not stand fairly for the election, i.e. be able to campaign and advise the membership of his candidacy, then the election will occur. He won't get to stand for the election, and he's without a remedy at law, because then a new president will be elected. And he's looking at 4 years. I believe it's a 4-year term before a new president is elected. So that's the irreparable portion. I don't think there's really going to be any dispute on that. I'd be interested to hear if they don't believe that to be the case, but it's certainly nothing that there's a money damage for that you can quantify. It's the ability to stand for this election. So what we're trying to have done, Your Honor, is we have, as far as the relief we request that Mr. Shin be allowed to stand fairly for the election, i.e. he be able to advise the membership of his candidacy, he be able to campaign for the presidency, and that he be added to the official booklet, if you will, of candidates. There's a booklet of candidates that's been distributed to the membership, so such that it reveals who the people are that are running. Now, if Mr. Shin isn't a member of the entity, as Mr. Spencer says, I'm confused as to why he got this pamphlet, but he got the pamphlet. So, and if he's not a member of the entity, I'm confused as to why he would be conditionally approved to run for the presidency. Obviously, to be a president of an organization, you need to be a member. So I think that's a red herring. So these are the things that we want in as a way of relief. If the court's uncomfortable doing that, then just stay the election. There is an interim management committee clearly in place that's running the organization. Stay the election until all of the issues that Mr. Shin is dealing with World Taekwondo, via its appeal and any appeals of those appeals, which it allows him to do that, is resolved, such that he can then, we believe he'll be meritorious, such that he can then stand for election at that time. So that's the relief we're requesting. Now, we're all talking in circles around World Taekwondo and what's going on there. I want to be real clear. We're not trying to litigate the World Taekwondo issues before you, but they do relate, because that's why he's only being conditionally approved right now. They give that as the basis because of his appeal process. So I want the court to understand what that is about. And as I discussed earlier, Mr. Shin was the Secretary General of PATU. Now, he says it was the Oregon entity or the New Jersey entity. He was the Secretary General of PATU. As far as that goes, as the Secretary General of PATU, he had no governing ability other than to assist the president in what the president told him to do. In the process of doing those things, he became aware of activities by the then president, Mr. Choi, that he believed were mismanagement, and he reported those to World Taekwondo. That resulted in an ad hoc reform committee that met to review those claims, that they've had findings. And those are the minutes that you were looking at the beginning, Your Honor, as Exhibit 1. And in those, it states that Mr. Shin was the person who raised the concerns about the mismanagement and the financial issues. He was the person who raised those concerns with World Taekwondo, such that everyone would become aware of Mr. Choi's activities. Fast forward then to, that was in March of 2021. Then in July of 2021, we get Exhibit 2, which, I'm sorry, not Exhibit 2. Yeah, Exhibit 2. We get Exhibit 2, which is the notice of charge and preliminary suspension of Mr. Shin from World Taekwondo. And as a result of that, he's also suspended. They are suspending him from activities with Patu as well. So he then appeals this suspension. And to be clear, the suspension has a number of charges that we believe are meritless, that largely paint him with the same brush as Mr. Choi, dealing with entity formation and dissolution. But again, let's don't forget, Mr.
I'm
Shin
a little unclear. Did World Taekwondo find that he find these charges, or did Patu find these charges?
Well, World Taekwondo is saying that they have alleged these charges, and now there is a tribunal that is being constituted to determine if they're valid or not. So he has an opportunity to defend himself. World Taekwondo. But as a
separate entity than Patu.
Yes, as explained by Mr. Spencer, and I did not disagree with that. I mean, it's that hierarchy. You have World Taekwondo, and then you have the 5 different regional governing bodies.
I guess my question is, how can I do a TRO on this? I guess I can see possibly a stay, but how can I do a TRO on this when the World Taekwondo process hasn't worked its way out? I mean, you're asking me to basically, you're saying, your client is saying, hey, I'm innocent of these charges, but I don't know if he's innocent of them. He might be, he might not be, but isn't that really up to World Taekwondo to make that determination, and then you can challenge it?
I don't disagree with you, Your Honor, if that was what the crux of the case was about, but it's not. So that is the side issue, if you will. It is what Patu relies upon in giving him only this conditional approval to run. So I'm only asking you to enjoin Patu. I'm not asking you to enjoin World Taekwondo. I'm asking you to enjoin Patu, who has said you are conditionally accepted to run for president. Well, I see him shaking his head, but I'm reading it, Exhibit 5. We're conditionally accepting his application under the following terms. He can submit his application to Patu elections, but approval of the application remains subject to the outcome of his appeal. So that the reason I bring that up is because Patu is not allowing him to do that. Patu does have, in addition, Your Honor, and we've alleged these causes of action, they do have their own bylaws and statutes that they are supposed to follow that deal with ethical concerns and violations. And in those, they are supposed to have specifically, I'm just looking for the actual reference for you. You can't be sanctioned under their bylaws and statutes of Patu, unless there's an investigation and an investigative report by the ethics committee and then deliberation by Patu sanction committee. None of those things have happened at all within Patu, at all. They're relying solely upon the activities at World Taekwondo for purposes of not allowing Mr. Shin to stand for president.
Anything in the bylaws that allow them to use an investigation or
they're silent. They're silent, but they do specifically reference the Patu sanction committee needs to be involved and the Patu ethics committee. And World Taekwondo clearly is not that.
Okay.
So what we're asking, I'm sorry, go ahead, Your Honor.
I was going to ask Mr. Spencer to respond to that.
Oh, okay. On that one issue, or I was.
Your Honor, there's a number of misstatements there, but this is the key issue that, and I agree with you. We are not here to litigate whether Mr. Shin engaged in misconduct or not, or to resolve the investigation going on at World Taekwondo. This is the primary crux of the issue. Mr. Shin has been suspended from membership and participation of any World Taekwondo related entity, affiliated entity.
So Mr. Shin's membership in any of these organizations, not just the Pan American organizations.
And this was by PATU or by World?
This is by World Taekwondo.
Okay.
So this is, and that's my point. PATU Texas has no, we have no relationship with Mr. Shin. We don't have we PATU Texas do not have an investigation against Mr. Shin. We PATU Texas don't have a complaint about how Mr. Shin and his associates handled money in the past. That is a complaint that's being investigated by World Taekwondo against these other Oregon and New Jersey entities with whom Mr. Shin is affiliated. Now, PATU Texas can only accept members who are in good standing at World Taekwondo. If you are suspended from World Taekwondo, you cannot be an active member in any of the continental unions.
Then how are you letting him, I guess my question then is, how are you letting him run for president at all?
Well, we're not. We have said to him, in effect, and the language in the suspension letter isn't as clear as it could be, but it's basically saying your membership is in limbo. You cannot be a member, and therefore you cannot run for president until World Taekwondo qualifies you through its investigation. Now, the complaint—
I thought it said he could run for president, he just couldn't campaign.
No, there's a number of different restrictions on it. And our concern is if he were to be elected president of PATU Texas by some court-enforced procedure that we go through, we, PATU Texas, would then be in violation of our agreements with World Taekwondo, because World Taekwondo has taken a position that Mr. Shin is suspended. And World Taekwondo at that point risks losing affiliation from the IOC.
Why didn't PATU Texas just say, hey, look, until this suspension is lifted, you can't run at all? I guess that's the confusing part to me.
Well, I can dig down into that, but the kernel of the issue is, I would phrase it twofold. They have to show they have a cause of action. They have not shown a cause of action because they have no relationship with PATU Texas. The relationships they've alleged in their petition are all based on relationships with PATU Oregon and PATU New Jersey. So those obligations, those allegations are all different entities. The only relationship he has with PATU Texas is an application to run for president. And PATU Texas has said, we will consider that, but you have to resolve the World Taekwondo issue first, which is consistent with PATU's regulations, PATU Texas's regulations, and with World Taekwondo's regulations. If you were to enter a temporary injunction or a temporary order, that could potentially put PATU in this impossible situation where they are being forced to violate their covenants with World Taekwondo. And that's not either fair or acceptable, and it's not likely that this cause of action is going to prevail, given that Mr. Shin is not a member of PATU Texas. He's conditionally applied to become a member.
I guess what you're saying, he is a suspended member. Is that what you're saying?
No, he's a suspended member of World Taekwondo. And in that
In order
status,
to be a member of PATU Texas, he has to be able to be a member in good standing of
World Taekwondo. He has applied, he's implicitly applied for membership, which is fine. We're happy to consider the application. He has directly applied to run for president. And as Ms. Macaluso said, and I agree with her 100%, obviously you've got to be a member before you can apply to run for the president. It wouldn't make sense to have a president who's not a member. But he can't be a member and he can't be president until he clears up his problem with World Taekwondo. His complaint is with World Taekwondo. It's not with PATU Texas.
So, Your Honor, if I could, maybe I can let the air out of the tires so it'll fit under the bridge instead of trying to shove something that's too tall through the bridge, under the bridge. the issue, I mean, if that's the case, then the TRO, the alternative relief we've asked for is to give us the TRO that keeps the election from happening on the 9th. We have a full evidentiary hearing. We come in here, we provide you with the information that you need to understand whether or not that needs to have a temporary injunction issued until such time as World Taekwondo finishes its appeal process, or Mr. Shen appeals, we feel finished with that appeal, the full appeal process that may be there. And we can explain all of that at a TI hearing as well. We prevent evidence. I mean, this is for a TRO. I'm not asking to win the whole lawsuit today. I'm asking for a TRO. That's a 14-day TRO.
So is it accurate that your client's membership in World Taekwondo is suspended?
I mean, that's what their letter says. I can't dispute what the letter it says. The letter says we're suspending your membership. And he's appealed that.
Is it accurate that in order to be a member of PATU, he has to be able to be a member of World Taekwondo?
I don't know that to be the case. I think he may already be a member of PATU. Now, to the extent that World Taekwondo is trying to say that its suspension affects him being suspended with PATU, I mean, that's the argument that they're making, Your Honor. But we believe that if he was not a member, why would they say we are conditionally accepting your application for president under the following? So, I mean, I don't, Exhibit 5 is makes it pretty clear. Yes, you can do these things, but we're waiting. We want to see what happens with this appeal. The problem is the appeal isn't it's going to be longer than October 9th. And at the time this letter was sent, the election was supposed to be October 11th. They've now moved it up to October 9th. Why is anyone's guess? Maybe in a rush to get it done before he can fully have his appeal process play out. So what he's asking for is the ability to stand for president. And he won't have that ability if this election goes forward on the 9th. As far as causes of action, we do have causes of action. We have declaratory judgment cause of action. We have breach contract. And we have this invalid corporate entity acts. Now, at the end of the day, with regard to those causes of action, there is a probable right of recovery because we can dispute a number of these things. And we feel that he will be successful upon those appeals. And as far as the declaratory judgment goes, those are pretty straightforward. They are definitely preventing him from running given this letter. So, I mean, we can satisfy our burden for purposes of a TRO.
Okay. I think I've heard enough here. I'm going to deny the TRO at this point. Do you have a proposed order, Mr. Spencer?
I have not prepared one, I've been in this for about 14 hours, so I will prepare one today and get it to you. I'll circulate it by opposing counsel first.
Okay.
And make sure that on the denial that it includes that the beginning that it was this hearing was held on October 1st, and make sure you obviously share it with Ms. Macaluso, email it to my court coordinator as well as e-filing it. Okay.
I will. Thank you, Your Honor.
Thank you guys. You guys have a
Nice
good
seeing
day.
you, Judge. Take care.
Good to see
Bye-bye.
you guys.
Bye.
Okay, let's chat again with Ms. Emerson. Did you guys work everything out?
Yes, we've got 2 days next week that we can do depositions. We may still have to have live testimony unless we can move the hearing back. But we've got to check with the 2 witnesses from our side that they want about availability to see if we can squeeze those in.
I'm happy to move back the receivership hearing if you'd like, and that might increase the chances. I don't know if you guys have been following the news. The COVID numbers have been getting better nationwide. I don't know if that's going to be good enough to get us out of red, but we move this back, it might increase our chances of being able to do this in person. But anyway, why don't we move this back 2 weeks or so?
Your Honor, if I could, I would prefer to keep the hearing. We've, like, as Ms. Emerson said, we will agree. We've set aside 2 days in the next week in order to take the depositions of witnesses. So we can just present that evidence either via video or via transcripts, whatever is easiest for the court. And we're going to work in good faith to get those both done on the 5th and the 6th, which will allow us to keep the current hearing on the 10th. If we're not able to, I can't promise that we won't have a live.
Or what day? What day?
11th.
Oh, the 11th. I'm sorry. I can't promise that we won't have a witness that we need to call live, and that's really based on the witness's schedule, not ours. But I have said to Miss Emerson, whatever days work this
Is there
next week, I will.
something coming up that makes this really urgent? Is there like an election or something that we need to get this done right away?
No, Your Honor.
Well, yes, there is something urgent, Your Honor, and we have this as part of which I'll be setting as well, a motion to compel inspection and entry. We have a situation where we have a roof on a building that has had continual water penetration for now what amounts to 15 or 16 years. The structural integrity of the building has apparently not been investigated by the association. We had our engineer out there last week. We were denied entries to some portion of the roof, and we are being told that, and they have reports in hand as well that document back from 2018 and 2020 that the concrete underlay has been saturated. So I this hearing is very important so that we are allowed to really fully evaluate and have a receivership in place that will fully evaluate the structural integrity of the building. This is Preston Towers, Your Honor, and it is a sort of iconic building in Highland Park area, but it's an older building. And there's considerable deferred maintenance on it. So we have serious concerns that has not been appreciated by the current board, nor their previous management company. And while I appreciate that they are making efforts, we don't think it's sufficient at this point in time. So we really feel the need to keep the hearing as scheduled on the 11th.
Your Honor, many things I disagree with that, but it's more the substance of the motion that we're not here to talk about today. But practically speaking, no, there's no urgency. Materials necessary to do a roof replacement are 200 plus days out. I mean, nothing that plaintiff's motion seeks can change the practical circumstances of the market, how long it takes to get an organization like an association of a high-rise condominium funding lined up. They've been working on that for months. They've got 3 roofing companies out there doing bids for emergency repairs and sucking water out of the roof. We all understand there's problems with the roof, but they're being addressed, and there's nothing there. It would make no difference to move this hearing out 2 weeks.
I was thinking either the 15th or the 22nd, just to give you a chance to get the depositions done.
Your Honor, again, I if the court tells me I need to move it, I will. However, that all of the actions that have been taken by the board are
Do the 15th to the 22nd, either of those work for you?
The 22nd, I'm out of town on the 15th.
Chris is out of the office on the 22nd. The 15th. I think we could make it work, Your Honor, but I really, again, we set this motion. I see no reason to delay the motion. We've reached an agreement with counsel to get the depositions.
I've tried to be nice about this, but I am going to move it. So you can keep talking, but I'm going to go ahead and move it. And the more you talk, the more I'll move it out. So no offense, but let's get this. You said you cannot do the 22nd?
I think that was Miss Emerson saying that. Oh,
I can't do this.
Oh,
But
well,
she said she couldn't do the 15th. She said she could do the 22nd.
I can do the 15th, Your Honor.
But you can't do the 22nd.
No, and
Do you want us to get with your
This is
court
what I'm
coordinator?
going to give you guys 3 dates. So you each get to veto one. Okay. So the 15th, the 22nd, or the 29th. You'll have to figure someone. You're both with bigger firms or reasonable.
Oh, no, Your Honor, I'm a 2-person firm. I'm not with a bigger firm.
All
It's
right.
myself and one other. And
There's only 2 people here that know anything about this case. My
All right,
veto will be the 15th, Your
the
Honor.
22nd, or the 29th. You each get to veto one.
I choose the 15th.
You're vetoing the 15th. Okay. Which one do you want to veto, Ms. Astron?
I would veto the 29th then.
So you can someone can cover the 22nd.
Yeah, I'm going to have to make it work.
Okay.
it'll be, let me see, right? Let me see. Hold on one second, my calendar, I need to change it to week format, just 1 second so I can see better.
Okay.
A second. Since there's only myself, Mr. Payne, I guess I'll have to take the 29th and then veto the I'm not going to veto the 22nd, but I mean, if Miss Emerson, if there's no one in their firm, it's only 2 people in ours.
So the 29th is what you guys want?
Thank you, Your Honor.
All right, we'll do this the 29th at 10:30. And just to make it clear, and Ms. Emerson, if you can prepare an order on this, each side will be allowed to take 2 depositions. The depositions need to be finished by the 22nd. I'd like transcripts with line and page designations submitted to my office by the 28th, so I can read it the day before. We'll do the hearing on the 29th. And anything else, guys?
No, thank you, Your Honor.
So,
So,
Ron,
Your Honor, can I? So each party gets to select 2 depositions? Or
Yes.
so are we talking a total of 4 depositions that we can submit?
correct.
Okay. So my
So-
question is, okay,
Go ahead.
is that precluding, is that precluding live testimony at the hearing then on the 29th? Or is that in addition to potentially? I don't want to have Ms.
We'll
Emerson say
see.
we don't want any
We'll see.
depositions. Okay.
I mean, Miss Emerson, I would encourage you, if there's another person that she really wants to take, I'd like to get this all done via deposition if possible. So she mentioned she needed 2. You said you needed 2. So that's how I came up with this idea. But if there's a realistic need for another deposition, I encourage you to work with her to get the other one set up.
Will do, Your Honor.
Okay. Anything else, guys?
That's it. Thank you, Your Honor.
Ms. Emerson, make sure you submit that order to Ms. Astron, and then make sure it includes that this hearing was heard on October 1st, and share it with her, and then e-file it and email it to Rhonda.
Thank you, Your Honor.
Thank you, guys.
Thank you, Your Honor.
Okay, our next hearing is give me a second. The next hearing, I believe, is on Pham v. Robinson. Is that correct?
Yes, Your Honor.
Yes, Your Honor.
Yes, Your Honor.
Are both sides here on that?
We are, Your Honor.
Okay, who's here for the plaintiff?
I am, Your Honor. My name is Lauren Cadillac.
Okay, and who's here for the defendant?
Good morning, Your Honor. Richard Barrett, Quatera with Thompson & Co.
All right, anyone else here on this case?
Yes, Your Honor. Bob Clark on behalf of Raymond Robinson, who I don't believe there's a hearing any motion directed against him, but well, I'm not
You
sure.
just wanted to be here just in case. Okay,
And Brandon Hackery on behalf of Turak Capital Partners, and same situation as Mr. Clark. I'm just monitoring, and I apologize for my dogs.
that's no problem. Happens to me too. It's the air of Zoom. All right, let's go on the record on cause number DC 215825, Pham v. Robinson. Counsel, make your appearances.
I'm Lauren Cadillac for the plaintiffs, Your Honor.
Yeah, good morning, Your Honor. Richard Barrett, Quatera for the 2 named defendants, Sunset Equity Funding and Easy Financial LLC.
Why don't you just ask Mike how he wants to?
All right, these people need to be muted. Okay, Mr. Clark, if you could make your announcement.
Yes, Your Honor. Bob Clark on behalf of Raymond Robinson.
Mr. Hikari, if you could make your announcement.
Yes, Your Honor. Brandon Hackery on behalf of Turak Capital Partners, LLC.
And there is a jury Rodriguez on this. Are you here for this hearing or something else?
Your Honor, she's Oh, I'm sorry. She's an associate working for me. I asked her to, she's pending bar results, and if it's okay with Your Honor, I would want her to observe.
Oh, no problem. Just want to make sure we got all our announcements. All right, we're here on a plea to abatement. Why don't we go ahead and proceed?
Yes, good morning, Your Honor. Richard Barrett Quatera. We represent the named defendants, Sunset Equity Funding and Easy Financial LLC in this case. We've requested an abatement on 2 grounds. Number one, there's a defect in the parties. Defendant Sunset Equity Funding is really a DBA for Easy Financial LLC, the other defendant. And the proper name for Easy Financial LLC is Easy Financial LLC, DBA Sunset Equity Funding. We request that this case be abated until the misnomer of defendant Sunset Equity Funding is resolved. That's ground number one. Ground number two is that the 2 named defendants were sued under the Texas DTPA, and there's a pre-suit notification requirement under section 17505A of the Texas DTPA Consumer Protection Act. And that specifically requires that the consumer serve a letter stating the amount of economic damages, the damages for mental anguish and expenses, and attorney's fees. And that's under section 17505A. And I'd like to share my screen if I may.
Sure. Let me make sure it's enabled. Yep.
And you should be looking at section 17.505A. Does everybody see that?
Yeah.
Okay, thank you. Under this section, it says under A that a consumer
I'm
shall
very
give.
familiar with this section, so you don't have to read it to me.
Okay,
That's
fine. Thank you. I'll unshare it then.
Thank you, though.
Yeah.
I've had to deal with this a number of times over the
All
years.
right. There was no written notice given by the consumer prior to filing the
I think
lawsuit.
there's automatic abatement in this situation. At least that's my understanding of the law.
Yes, there is an automatic abatement, but there's also a requirement that we still are requesting the 60-day notice be given to us because there's been no allegation of damages against my client. The only damage claim in the lawsuit is under the venue provision and jurisdiction, over 200,000, but less than 1 million. So we have no idea what the damage claim is against us, number one. Number two, they've requested mental anguish penalties, and we have not received any damages regarding mental anguish. We've not received any doctor's orders that's required to be produced under this pre-notice notification under the DTPA. So we're asking, and there's been no medical records given to us under the DTPA. So what we're asking for is really 3 things. Number one, to be given the proper written notice under the DTPA specifying the damages against my client, the mental anguish damages, and also the medical records and the attorney's fees that are required to be produced under this DTPA notice. And I would like to point out that we served our request for disclosures on August 20th. And as you know, under the request for disclosures, you're supposed to produce documents or identify documents that are related to the case. You're supposed to give a statement of the damages and produce medical records for mental injury. That notice was served on August 20th. It was due on September 20th. So we have no idea what the damage claim is against our client. So what we're asking for is really 3 things. We've got an amended order granting the motion to abate that we gave last night, and we're asking for a date that the plaintiff give us the DTPA notice and the required items under the DTPA notice. We're asking for a date where the plaintiff will correct the misnomer of naming the wrong defendant. And then also we're asking for a date to abate the lawsuit, because this section 17505 is not real clear on when the abatement ends. So that's what we're asking for. Thank you.
Ms. Cadillac?
Yes, Your Honor. First, as to the naming of the entities, my client is a regular person who was trying to learn how to flip houses, ended up finding Sunset Equity LLC. And Sunset Equity LLC is written all over the documents sent to my client in relation to the loan that's at issue in this LLC, or I'm sorry, in this lawsuit. When we search Sunset Equity LLC in the Texas Secretary of State, their right to do business in Texas has been removed. The Texas Secretary of State does not allow them to do business. From what we could find in the record, Easy Financial LLC is allowed to do business in Texas, but only got that ability after they issued the loans to my client. So if there is a misnomer to naming, I would certainly ask that the defendants provide their paperwork from the Secretary of State, and that is in my discovery requests to them. From the documents that my client provided, and these are loan documents and closing documents, Your Honor, there are multiple entities: Sunset Equity LLC, Easy Financial LLC. The owner of both of those is a licensed attorney in the state of California. His name is Ben Donnell. We did not send a 60-day letter because we knew Ben Donnell was a licensed attorney in the state of California. We knew he needed to be registered to do business and make loans in the state of Texas, and we knew he failed to do so. We had a feeling that he would evade any type of service, and I have 106 affidavits on file with the court that prove that he did indeed try to evade that service. As to the 60 days, Mr. Barrett, I'm sorry, I'm going to totally ruin that last name. Quatera?
Quatera.
Quatera. Okay, I'm sorry. Mr. Barrett Quatera contacted me personally on July 15th, 2021. In that email contact, he told me that he represented the defendants, and he asked that we could come to a Rule 11 agreement regarding when their original answer would be due. We did enter that Rule 11 agreement, and it is on file in the record with the court. I counted yesterday, July 15th is 77 days before today, Your Honor. They had the requisite notice. The 66 days has long since passed. For Mr.
So you said you actually did send a notice.
We did not send a letter prior to filing the suit, Your Honor, because we had a feeling, and the defendant proved to us, that he would avoid service. So we did not want to give him an opportunity to hide assets and clean up his mess. Have
you filed a notice since a DTPA notice since you filed the lawsuit?
Just the lawsuit, Your Honor.
And is there any case law? I've always understood, but I haven't looked at this recently, that a DTPA notice is required. It's required, that there's not some way to avoid it because you think the defendant is going to evade service, or the lawsuit can be a substitute. Is there some case law out there that says that there's no longer no longer requirement that DTPA notice be sent out?
My understanding of the case law, Your Honor, is that if you file suit, there is an automatic 60-day abatement, and we are now at day 77 after his attorney contacting me.
You're not required to, and you have case law that says you're not required to file a DTPA notice at that point.
I don't have any case law with me, Your Honor, but I'd be more than happy to go back, as my understanding of the law is that the lawsuit itself serves as notice.
I don't believe that's the law, but if you want to give me some case law, if you don't have any at this point, I'm going to go ahead and grant the abatement then. So I guess the question is, we've dealt with this issue before. I assume you're going to send out a notice, Ms. Cadillac?
Yes, I absolutely will, Your Honor.
And so, so in the abatement period is 60 days, is that correct?
Yes, Your Honor.
Well, you know, Your Honor, the abatement period, if the document that I had shared under Section E, the abatement period under 17.505 E says that the abatement continues until the 60th day after the date that written notice is served in compliance with subsection A. So it's not real clear, but I think the abatement is in effect for 60 days after we get the notice. So I think we're abated right now up and through we get the date of notice. So our amended order granting motion to debate has 3 line items to complete. One is a date for the plaintiff to provide a written notice. The second item is for the plaintiff to correct the misnomer, because we put in our verified answer that there was a misnomer of the original, one of the defendants, Sunset Equity Funding. That needs to be corrected. And then also a date until the abatement is actually a date that this whole case is abated through.
Your Honor, as to the naming of the companies, I would argue that the defendant has the burden to show.
I'm not going to debate on that grounds. I'm going to debate on the grounds of the DTPA. So why don't we do this? We'll go ahead and abate this and include as part of the abatement if the abatement is not, if the DTPA notice. So in the abatement order that you prepare, Mr. Barrett Quatera, if you could include language that says that if they fail to file a DTPA notice letter within 30 days of today, then the case will be, the DTPA claims will be dismissed. Does that make sense?
Yes, Your Honor. Yes, Your Honor. And I'll circulate that to plaintiff's counsel.
And Your Honor, would e-file then be considered the day they receive it when we e-file the letter?
Well, you need to, whenever, I think the date goes from the date you sent it to them.
Yes.
You also need to e-file it as well.
Okay.
So
We'll make sure to do it the same day.
Yeah, Your Honor. Yes.
Sure, Mr. Clark.
One, this abates the entire case, not just the claims. And secondly, I'm not sure whether we were part of the DTPA or not. Ms. Cadillac might want to address that. And third, does it abate things like a motion for a 106 order because there's a hearing set on that? Would it abate that also?
Why don't you share the language? Usually the cases I've had have just been DTPA cases, but can you share the language again of that statute? Does it abate the entire case? I thought it abated the entire case.
No, hang on a second, Your Honor. Can everybody see it?
Yeah.
Okay.
Yes.
It is, my understanding is that it is abated to the entities that have DTPA claims against it.
That was my understanding as well.
So the only 2 entities that have DTPA claims are against my clients, Sunset Equity Funding and Easy Financial LLC. So it's my understanding that the case is abated as to those two defendants only.
That was my understanding as well.
Judge, I'm looking for the pleadings to see if we're part of the DTPA. Maybe Ms. Cadillac can give us a heads up on that.
Off the top of my head, Mr. Clark, you are not. And the hearing you're referencing is a motion to serve via social media, which is another defendant that has been evading service. So as Mr. Clark, your client has already been served and filed an answer.
Yeah, right. But we have standing on something that has to do with service through social media, because I want to be heard on that, because that has a lot of public policy aspects to it.
I disagree about your standing, but that's something I think we're supposed to address at that hearing.
Well, I think standing, yeah. Your Honor, I didn't hear what you said.
We will address that at that hearing.
Okay.
I've reviewed the petition and the only DTPA claims are against my 2 clients.
Okay.
Okay.
May I unshare the screen?
Yeah.
Thank you.
Okay, anything else, guys?
I'll get an order circulated today to plaintiff's counsel, and then once we get agreement, we'll file it with the court for signature.
All right, great, guys. Thank you so much.
Thank you,
Thank you,
Judge.
Thank you, Your Honor.
Thank you.
Everybody else, I'm going to be taking a quick break, but I'm going to keep